Good morning, everyone. It is a pleasure to welcome you on behalf of AIPPI Young Members Committee to this webinar entitled Rethinking Copyright in the Age of Artificial Intelligence, organized in collaboration with ASIPI Joven. AIPPI Young Members Committee is one that brings together the young members of the association with the aim of fostering their active participation, promotion of and the exchange of knowledge, and strengthening the global network of young professionals in this field. This event is part of the Memorandum of Understanding between AIPPI and ASIPI Joven, which seeks precisely to create spaces for collaboration and shared learning. Today, we will have the opportunity to reflect on a fascinating and complex topic, how artificial intelligence is transforming the way we conceive authorship and ownership in copyright law. We thank you all for joining us and invite you to enjoy the panel and take an active part in the association. I hand over the word to my colleague Diego from ASIPI Joven.
Thank you very much, Blanca. On behalf of ASIPI Joven, I am pleased to extend a warm welcome and thank you everyone for joining us today in this webinar. ASIPI Joven is an initiative within ASIPI that seeks to promote active participation for young professionals, foster leadership, and strengthen the connection with international IP community. This event in particular is significant to us, as it is the second webinar organized under the MOU between ASIPI and AIPPI, a collaboration that continues to create opportunities for learning and dialogue for our generation. Without further ado, it is my pleasure to introduce to you Jose Antonio Fabara, who will be moderating this insightful discussion. Jose Antonio has over 10 years of experience in intellectual property, sports, and entertainment law. He's a senior associate at Bustamante Fabara, where he leads the sports and entertainment law practice. He is the former advisor to Ecuador's Ministry of Sports, holds a master's in sports law and management from the Higher Institute of Law and Economics in ISDE, Spain, and a specialization in corporate law from Simón Bolívar Andean University in Ecuador. Jose Antonio, the floor is yours.
Thank you, Diego and Blanca, for the introduction. Good morning, afternoon, evening to all colleagues from ASIPI and AIPPI. Welcome to this wonderful joint webinar called Rethinking Copyright Ownership with Artificial Intelligence. It's a pleasure to moderate today's session. In the next hour, we'll examine one of today's most pressing IP questions. Who owns works created with or by AI? We'll compare different approaches and connect with recent jurisprudence as well as recent AIPPI resolutions. For this webinar, we are going to have two great speakers. Yağmur Aktan from Turkey. She is a senior IP and legal consultant at Invocat IP Services with nearly 10 years of experience in copyright, patent, and IP litigation, as well as international portfolio strategy. She's the author of Perspectives of Generative AI Outputs and Authorship of AIPPI Turkey Journal 2024, and she holds an LLB from Marmara University and is a frequent AIPPI speaker on AI and copyright. Welcome, Yağmur. And Marco Tena from Mexico is head of the Intellectual Property and Regulatory Compliance at Vega Guerrero and previously worked at Dentons and Goodrich and Riquelme. He's an CP member and holds a specialization in IP and regulatory compliance from the University of Pennsylvania. He has over 8 years of experience in IP litigation, corporate practice, and fintech. So you may ask, why does this topic matter now? Copyright and ownership have always sparked debate. Just think of the famous monkey selfie case or the recent controversies around Midjourney AI platform. Now, artificial intelligence brings a whole new set of challenges and questions to this discussion. With rapid advances, AI is able to perform tasks that were recently considered to be exclusive domain of human creativity and reasoning. As the result of such new discussions, our traditional concepts of authorship, originality, and ownership have been fundamentally changed by these new capabilities. Expect in this webinar a practical comparative discussion with clear takeaways from our speakers. And with that, Yağmur, you have the floor for your presentation. Thank you and welcome again, everyone.
Thank you, Jose Antonio, and thank you to AIPPI and ASIPI for inviting me to this webinar. I hope everyone finds this webinar useful. And first of all, I want to say a few words about human creation and AI creation. As you know, copyright law is fundamentally a deep structure that protects human creativity. Creativity expression is basically the artist's way of communicating their emotion and ideas through an art form like painting, music, or writing. In its simplest form, copyright protects a work that shows the author individuality or originality and that has been fixed in a tangible form. And throughout history, we built this system to reward and protect that creativity copyright. This system has enabled the artists to make money from their work. However, this increasing use of artificial intelligence in content creation is now bringing huge challenges to these traditional copyright principles. Now, we have a powerful artificial intelligence that can analyze as many works as a human would see in entire lifetime in just 5 seconds. For current copyrights law, AI is playing a dual role. It is both a great training tool and a major threat. For example, in a recent interview we did with a Turkish musician, she shared something interesting thoughts with us. She said, AI sometimes make things easier. It is great for simple tasks like creating samples. But on the flip side, she also mentioned that AI-generated playlists, example, are being pushed forward, which is creating unfair competition. They even added that functional groups like AI bands are starting to emerge. So alongside conveniences, it's clear there are also many infringements happening. So to frame the legal debate we are seeing today, we can really boil this huge discussion down to main problems. The first problem is we can call the input problem. This is simply about training the AI. The basic question is like that. Should AI companies be allowed to use millions of copyrighted books, songs, and images to teach their models without asking permission or paying for it? This is the core fight over all the protect material the AI consumers to get smart. And second, we have another problem, output problem. This is about the final finished product the AI creates. And the question here is, who actually owns the copyright on something an AI makes? Or does the protection go to the person who wrote the instruction, the prompt writer? Or does it go to the company that developed the AI model? Should that AI generated work just be free for everyone to use? These questions, what the AI takes in and who owns what the AI puts out are the center of the legal challenges faced. Today, the secret behind how powerful these AI models are is the unauthorized use of millions of copyrighted works. So how do they get all this content? Through a process called text and data mining, or we can say shortly TDM. So what is exactly TDM? Think of text and data mining as a way AI eats and learns. It's an automatic process where the AI scans and analyzes massive amounts of data, things like books, articles, or web pages, to find hidden patterns and relationships. Generative AI systems need huge amounts of data to even function. TDM is a critical step that collects and prepares all that training data. It extracts those patterns, and then AI uses those extracted patterns to make predictions or generate new things. Now, here the legal topics, because TDM involves automatically copying these massive data sets, which often contain copyrighted works. It directly hits the right of reproduction, a fundamental right of the copyright holder. The law sees this systematic copying as a necessary technical step to teach the AI, and that's exactly where the conflict starts. When it comes to unauthorized use of this training data, different regions have taken different approaches. Example, in the US, the approaches is usually fair use. Generally, training an AI model is often seen as a transformative use. However, because this is decided case by case in the courts, it creates a lot of uncertainty for AI developers. And other side, in the EU, they introduced specific TDM exceptions with an opt-out mechanism. This basically means developers can use works for training, but creators are supposed to have an explicit right to say no or opt out of this use. However, many people criticize the EU system because the TDM exceptions was designed to just extract information, not to create completely new expressive content, which is exactly what generative AI does. Plus, the opt-out system isn't really working because most creators don't have the technical means or knowledge to effectively use that right. Maybe a better solution, many argue, would be to switch to opt-in system or some form of collective licensing. This would give creators more control and ensure they get some compensation for their work being used. And finally, using this training data brings up two major headaches: liability and transparency. It is incredibly difficult for a court to decide if an AI output illegally memorized and spat out a copyrighted work, or if it's legally learned from the work to produce something new. And if the AI outputs does infringe on copyright, who is responsible? Or is it the company that developed the model, or the company that uses the model commercially, or the end users who typed the prompt? This leads us to transparency. Creators need to know if their work was used. So AI systems are being asked to publish details, summaries of the copyrighted works they use in their training. This is a difficult balancing act, as they need to protect their trade secrets while still giving right holders the information they deserve. And now, actually, I can give some example under the input problem topic. Example, the New York Times lawsuits against OpenAI and Microsoft. The New York Times claims that millions of its articles were used without permission to train the AI, and that ChatGPT is basically copying that content and causing them to lose subscribers. And the outcome of this case will fundamentally change the future of the AI industry. If the New York Times wins, AI companies might have to pay huge licensing fees for the content they use to train their models, which will drastically increase their costs. Most importantly, the court's decision will determine whether AI systems using copyrighted materials constitutes fair use. This will set a new rulebook for how content owners on the internet can protect their rights against AI. It will essentially redraw the rules for the future content creation. Another case, Getty Images versus Stability AI. This is also about the input problem. Getty claimed that Stability AI illegally trained its stable diffusion model using millions of their copyrighted images. The most interesting part of the court decision was this. The judge rejected the secondary copyright infringement claim because the court decided that the AI model scored what we call the model weights doesn't actually store a direct copy of the Getty images. To understand the model weights, they aren't pixel by pixel copies. Instead, they are a statistical abstraction of the patterns found in those images. Like the AI learning, the sky is usually blue, or cat's ears are pointy like that. Since the model only contained this abstraction and not an illegal copy, the court ruled that distributing the model was not secondary copyright infringement. The court essentially accepted that the model weights could be considered an article under English copyright law, which usually refers to a physical object. Because of this, the secondary infringement claims were dismissed. However, this is crucial. The court's dismissal of the secondary claim did not solve the issues of primary infringement. In other words, the court did not decide whether copyright was violated during the initial act of training the model. That first moment, the training data was copied. That critical question remains unanswered by the court decision. Now, second main problem, the output problem. This is simply the question of who owns the final piece that creates. Sorry. In places like EU or Turkey or UK, our copyright system is completely human-centric. To get copyright protection, a work has to be authors on intellectual creation. It has to clearly show the creator's personality and their free and creative choices. The law is, sorry. the law is very clear. An author can only be a natural person, meaning a real human being. AI is not recognized as a legal person. So what does this mean? If a work is generated fully by AI with no real human creative involvement, it just doesn't pass the originality test. Under current rules, those works should just remain in the public domain, free for everyone to use. Because of these uncertainty, 5 different scenarios have popped up trying to answer that ownership questions. Example, first scenario about the developer. This says the copyright should belong to the person who programmed and trained the AI. The problem is this completely ignores the person who actually used the tool. And second scenario, this suggests the investor or the person who paid for the work should own it. Similar like how traditional corporate projects work. And third scenario, it's about hardware owner. This gives the copyright to the owner of the computer. This keeps things simple, but it totally abandons our traditional copyright ideas. The current law says protection depends on how much the human actually contributed to the AI output. If the human uses the AI like a paintbrush and keeps real creative control, the result might be qualified. But here is the kicker. Simple typing a few words into a text prompt usually doesn't count as a creative choice. Prompts are seen as unprotectable ideas. What counts as authorship? The true creative contribution comes from creative selection and editing of the AI output. This means things like setting very unique parameters before generation, or more importantly, selecting the best results and significantly editing and arranging them into the final piece. I have some examples for this topic. The Taylor versus Permuta case. This is all about who owns the stuff AI creates. The scientist, Dr. Taylor, tried to register a work 100% made by his AI, but the court said no. Their reason was super clear. Copyright protection requires a human author. That's all. And another one, the graphic novel, Zarya of the Dawn. In this case, the artist used an AI tools called Midjourney to create the visuals, but she wrote some unique texts herself. The US Copyright Office clearly states images produced solely by AI cannot be copyrighted because they were not created by a human author. However, the US Copyright Office did say that the artist's creative selection and arrangement and coordination of those AI visual with her own text, essentially creating the whole novel, was considered human contribution, and that part was protected. So the AI output itself was not considered derivative work, but the final product, which was creatively put together by a human using the AI output, was partially registered. So the big takeaway here, if you do creative and significant editing, you might be able to register to work as a derivative work, a new work based on the AI's output. If an AI output doesn't have enough human involvement, the most likely result is that it falls into the public domain. Another idea is to create a special limited time right called a sui generis right that is separate from copyright. This would offer some protection for AI content without forcing us to completely rewrite copyright law. But critics worry it will just make the legal system more complicated. So, what's the big takeaway from all these cases we have looked at? This debate around AI and copyright urgently needs action. And I mean, not just like a legal action. Actually, I mean also need global political action. Yes, political action is also so important now. Example, the government in the UK is currently in the middle of some lawsuits and protests regarding copyright. They have stated that the uncertainty over how our copyright framework operates is hindering the growth of our AI and creative industries. This situation cannot continue. So it looks like political decisions will be followed by legal regulations. This shows us how seriously governments are starting to take these issues. Right now, our existing copyright laws simple aren't enough to handle complex ownership usage problems that AI has created. It's absolutely essential that legal systems find balanced solutions and encourage two things at once. One, protection our traditional creators, and two, allowing AI technology to keep developing. We need solution and we need to look at them both fast and slow. I can say for short-term solution, it should focus on creating fair mechanisms for using training data. That means things like getting active consent or using collective licensing when AI models are learning. We also need clear rules defining human intervention in AI outputs. And also I can say for long-term solution, it should look at entirely new protection systems, sometimes called sui generis regimes specifically designed for AI output. The development of AI isn't slowing down, and so achieving this global agreement, this legal harmonization is definitely going to be a huge challenge, but it's a challenge we must face. And thank you all for your time and attention. And I will now return to our moderator, Jose.
Thank you, Yağmur, for your clear and great presentation. Marco, you have the floor for your presentation.
Sorry, I was muted. Thank you very much, Jose Antonio, and thank you very much, Yağmur, for your great presentation. I totally agree with the fact that there needs to be not only national regulation, but a global cooperation on this important issue. I'm going to specifically talk about how regulation has gone in America, because my colleagues from Latin and South America will agree and will know of this fact that most of the legislations in America come from different philosophies, different currents. So, for example, Mexico is more of a civilist country that follows Spain and France, but also intellectual property laws are specifically designed because of multilateral treaties celebrated with the United States. So the main changes in regulation we see and the main advancements we see in the countries in America usually come from the influence that the jurisprudence in America generates. So I'm going to start talking about, for our colleagues that are not totally related with intellectual property, intellectual property is split into two main areas that it covers. The human creativity. When we talk about industrial property, we have the creative protection of these industrial creations, but when we talk about copyright, we talk about the creative protection within the art realm, and this is generally accepted as a framework around the world to incentivize the development of creative arts and innovation. So a few years ago, I started my research on why these rights were as they are. I was specifically brought to the attention by the Dabus case, which is not specifically related to copyright, but it is a machine that attempted to obtain a patent right recognized through AI creation. But in essence, what I understood about authorship is that in the different philosophies of law that we see, at least in America, common law and civil law, copyrights are a recognition in civil law countries of a reward of your originality, of your creativeness, of your individuality, whilst in the common law, it's more philosophically justified as a recognition of the work or the labor that's set forth in creating the work of art. But in the end, both of these models are, as Yağmur correctly said, humanly centric. Both are seeking to establish a framework of protection that's related to the work of art that guarantees the right of protection of the art through the state. So this works as an incentive for individuals to continue creating, developing all these protectable works, since they know that the state will eventually protect them. So I'm going to be talking about how the evolution of jurisprudence has been going on in the United States to the point where we have the current position as is right now, starting with the Burrough-Giles Lithographic Company versus Aroni, which is a case about the initial recognition of photography as a protectable work of art. As many might imagine, the same issues of authorship and protection arose when cameras started going around. And the main issue with this case was that copyright was actually recognized for the photographers in the sense that there was creative intervention, creative direction in the way in which the photograph was presented and in the way in which the subject of the picture was dressed, for example. Secondly, Feist Publications versus a Rural Telephone Service Company in the United States in 1991. The Rural Telephone Company Service attempted to register for copyright different telephone books, but just ordered as they are and through chronological series and alphabetically ordered. So the Copyright Office determined that in that specific case, the human creativeness implies that some sort of order needs to be made. What I mean by this is that it cannot only rely on orders we see in nature, like a chronological order or order that is found by the letters, but the protection of copyright implies the putting into place human creativity that has human intellect. Also, as Jose Antonio mentioned, the gorilla selfie is a very famous case. Naruto v. Slater, it occurred in 2018, where an animal, well, a monkey took a selfie with a picture of a photographer, and afterwards, PETA, the Association for Ethical Treatment of Animals, filed for the copyright protection of said picture in favor of Naruto, which was the monkey who took the picture. And ultimately, there was no grounds recognized for PETA to act on behalf of the monkey. So again, the main conclusion with this case is that authorship implies some sort of human intervention. And as Yağmur mentioned earlier, Tyler and promoter, it's necessary for human authorship to intervene to acquire protection. So when I started going into the research of these kinds of issues, I immediately thought that all the information that was being put into the LLM, to the artificial intelligence, it was always open sourced. One of the first cases I saw was an IBM project called the New Rembrandt, where through the use of 600 paintings by Rembrandt, they recreated a Rembrandt painting or image. And well, in this case, there was no copyright infringement because all of the paintings were now part of the public domain. So when I started investigating these kinds of issues, I started running into well, it was the input issue that Yağmur was talking about was a non-issue or something that was not present for me, because the immediate thought was that everything that was being inputted was allowed, authorized, or open source. But as AI has been advancing through the recent years, we have seen that the training of these models, the LLM models, well, not necessarily, but in many cases require training through huge data sets and huge information sets. So the other relevant cases in terms of copyright that help us understand the different issues that arise in terms of the protection, these are more related to the input issue and the data that is being used to train the LLMs. But first we see BARTs and other authors versus Anthropic, which is actually one of the biggest payouts in recent history. I think it was around close to 1.6 billion for authors. And this is a settlement case because the potential indemnifications that would have to be paid under an agreement of this kind would be massive. There's currently no insurance companies willing to guarantee or protect OpenAI or Anthropic because of the huge liability that is implied, that can be implied. And in this case, they went into the fact that replicating material from authorized books, from copyrighted materials that were obtained legally was fair use. But the important fact about the Bartz et al. Anthropic case was that some of the content that was used came from pirated sites. So once the court determined that unlawfully obtained copyright materials could not be used to train data sets, that's when Anthropic took the decision to just accept whatever settlement payment they could agree with the writers, because the potential implications of being determined some sort of liability in this case was unmeasurable. Also, we have another case of authors, Kadri et al. Against Meta Platforms, but in this case, the court requested that there was a demonstrated use harm for a demonstrated harm in the market from the use that was carried out by Meta, and this couldn't be demonstrated by the plaintiffs. Also, New York Times versus OpenAI and Microsoft, which is a case that Yağmur spoke about. And the interesting case about this was that some of the evidence that was presented in these cases were literally the prompts requesting it provide certain cases, certain reports, or certain news from certain dates, and OpenAI and Microsoft would provide the identical text. So that was when the reproduction right was being exhausted. Also, lastly, the last case, Reddit versus Anthropic. Again, Anthropic being in a position of a problem. They're being sued for the unauthorized scraping of the content posted on Reddit, which also talks about the implications that are related to the fact that is material online just available for everyone, and is it considered for use to just read and use or replicate? So what we see through these cases, the first cases that were presented, were that we see for certain principles of copyright, there needs to be a human element where the human mind exercises intellectual conception and creative control of the work of art, and original expression, which is a very, very low threshold. In Mexico, for example, the threshold for originality is really, really low, but there doesn't have to be any artistic merit to the painting. So it doesn't have to be Picasso to be protected. It can be anything as long as it's original. It has to be an independently produced creation, not copied or mechanically assembled, with a minimal threshold of creativity. And in the case I was talking about regarding the telephone books, it was reaffirmed by the courts that there has to be a modicum of creativity needed, which is a minimum of genuine human creativity. And in terms of the use of copyrighted works, we see that the main principles that are overreaching the stance of the copyright office and courts in the United States is first that it is first used when the using copyrighted material is authorized, and it is transformative learning. Also, there has to be an oversight for the responsibility, and this is something that one of the first conclusions I came up with when analyzing these kinds of issues was that there needs to be human control and supervision to the extent that it can be explained how we got to where we are. And how the outputs were generated, but this could eventually lead to unnecessarily having to justify every creative work that is made. The data must be legal. Also, since we have seen that most of the litigation that has been filed against these AI companies is pushing towards the fact that they reveal where they obtained all of these material. And when analyzing the reproduction of these materials, there has to be a certain market harm. So in the end, the current stance of the Copyright Office in the United States, and which we believe, at least for the case of Mexico, will permeate through bilateral agreements, is that the copyright do need human authorship, and works that are generated entirely by not humans are not eligible for protection. And if a human is sufficiently contributing to the selecting, arrangement, the modification, coordinating elements of the work that include AI-generated content, then this content can be protected, but it has to be a case-by-case analysis. For example, as Yağmur also mentioned, Sari of the Dawn was this graphic novel which was created using Midjourney images for the pictures, and the U.S. Copyright Office recognized a certain, a partial protection for the text and the way in which the graphic novel was arranged and presented. There's also two guiding policies on AI. Where this position that I already stated is stated, and also the fact that applicants must disclose and disclaim where AI-generated portions of the work of art are. And also there's this third case of Theater de Opera Espacial. It's a Midjourney AI image that was attempted to be protected through the U.S. Copyright Office. The review board requested the applicant for it to exclude the AI-generated elements to obtain the protection, and ultimately the protection was rejected for this case. So what do we see towards the future, or what do we need to at least have in our conscience, is the fact that there needs to be like a modicum of creativity, which is a minimal spark. It needs a tiny amount of creative human choice of judgment, and that it's not the necessary conclusion of mere effort or routine, and also the fact that there is originality within choice. So I feel like these criteria is better to ask oneself as an author when creating these works of art. Is there a minimal spark of creativity where we are doing a certain choice with the lighting, with the presentation, with the colors, with the color use, and how the things are arranged? And if these things are original, like for example, just as a superhero drawing that replicates any other superhero that already exists, does not fulfill the originality threshold. So what do I believe will permeate the rest of the Americas because of this? I feel like there's a certain way, a certain route we're taking where creativity is being kind of graded. I think that creativity doesn't have to be graded to a sense where it's considered human or not, but in the end, if we are able to determine how the steps we took to reach certain work of art to be protected, then I believe that it would be easier for the copyright offices to determine if something can be created or not. And the second, the terms of harmonization. And as I was mentioning, Mexico has the current IP legislation as is because of the United States. Well, the trilateral commercial agreement between Mexico, United States, and Canada forced it to, well, obliged it to obtain modernized IP law and modernized competition law. So in the end, these criterias are being, well, they're being brought into countries in America through bilateral trade. And I think it's very important because in Mexico, there was a recent ruling where, well, an author attempted to seek protection for an avatar of himself created through an AI. And the Supreme Court ultimately ruled that no copyright protection would be granted because it is essentially a human right, a human recognized right. But it was very close to stating in the Supreme Court resolution that any work of art intervened with AI would become public domain. There was a public outcry, especially within the IP sector in Mexico, that the establishing this precedent, although not very binding for the rest of the world, could lead to potential lack of legal certainty for authors and companies that own works of art that are intervened with AI with certain things. And that's the thing with AI. AI is not necessarily only open AI, but AI are tools that help us achieve these faster results. So in the end, I do feel that that there has to be a harmonization of these criteria around the world, and eventually I do believe that we will be led to an open licenses agreement for the input issues, and for the output issues. I do believe that if the author is not able to explain how we got to a certain work of art protected, then protection should not be granted. But we will have to see. The trilateral agreement I'm talking about will be renegotiated next year, and well, Mexico and Canada and the United States are currently not having the best commercial relationship. So we will see how also geopolitics shapes these kinds of conversations. That's it. on my behalf, I yield my time to Jose Antonio. Thank you very much.
Thank you, Marco, for your presentation. It's really interesting, the recent development on jurisprudence regarding copyright and AI. We have a couple of minutes for questions, and maybe this question for Yağmur. Marco was telling us about this modicum of creativity that a work must have to be considered a work to be protected by copyright. And do you agree with this idea, or what's the level of human contribution that you think a work should have for the authorship threshold to be given to a human?
Sorry, there is a problem, my microphone. Actually, I agree because I think a work needs human contribution to be protected. Absolutely, I think not maybe just not enough, but example, if you need to have sufficient control over the expressive elements of the work, sometimes I think if your work shows a creative sparks and human hand guiding the final expressive product, you are likely over the authorship threshold, but also it's case by case analysis, but human creativity is definitely important.
Perfect. Thank you, Yağmur. And Marco, in hybrid works, who should own this the ownership of the work and the rights over the work? The developer, the user, the prompt author, the data provider, a team as a whole? How should this hybrid works should allocate the gaps between different people and softwares being involved in a single work?
Thank you, Jose Antonio. I think that is a great question, because it goes into the main issues I started running into first, like who has the right recognized. My idea is that the technology owner, the technology creator that creates the output should be the owner, but it is up to them to license, to authorize, to grant certain permission for creators to use their technology for their output creation. So I do believe that there is a certain level of authorship that should be recognized for the creator of the input, and but in essence, my idea is that whoever creates that technology should be able to determine how that technology is used and which rights are recognized. Because in the end, although authorship is the authorship comes from a specific creative idea that wants to transform or create something using that technology, I believe that it is because of that technology that you can create this. So like when we talk about cameras, for example, we don't think that Canon or Sony has the authorship of our pictures, but it is because once they sell the product, all the product that comes from that specific product is already licensed or authorized for being used. So I think that AI companies need to determine which model they want to put into place. And well, that is specifically my perspective, but always like I'm giving this right specifically to the technology owner because they created that technology and technically they used authorized inputs for their creation. If they didn't use authorized inputs, that's a different question, but I believe it should be the owner of the technology who should determine how, if any, if that work of art is protectable.
Perfect. We're almost out of time, but I have one last question for you, both of you. But please give a quick answer, as we only have a couple of minutes left. How do you think disclosure should be handled on AI-assisted works? I've read about the watermarks that should be included in for example, pictures generated by AI. But in general, how do you think disclosure should be handled in AI-assisted works? I don't know if you want to start, Yağmur.
Actually, before, as I said, we need clear rules that define the human's contribution to AI outputs for registration. Example, I gave a major case about the Zarya of the Dawn, and example, US Copyright Office just only protect the human artistic selection. That's because they lacked a human author. I think AI systems are also being asked to share detailed summarize of the copyrighted works they used for training, just transparent.
Thank you, Yağmur. Marco, I don't know if you have any input regarding this.
Yeah, I think well, ethical disclosing is a big part of the global current, not only before authorities, but in our work between parties, just as private parties, like even not only with works of art, but also in our day-to-day, as for example, lawyers. I believe that there has to be an obligation to disclose through watermarks or through waivers that these contents are being AI created. But what I know, like it's easy to remove a watermark like that, for example. So there has to be like some sort of level of technological locks or encryption data that allows us to see if it is AI created or not. But I do believe that there has to be not only like a legal obligation to disclose, but an ethical obligation to disclose by anyone who uses AI and intends to commercialize on these kinds of work.
Thank you, Yağmur and Marco, for all of your wonderful inputs regarding this interesting topic. Definitely, we've just seen the surface of the copyright and the AI work discussion, and I'm sure that in the next couple of months and years, we're going to have a lot of developments regarding ownership of copyrights, given the new capabilities and advancements of the different AI platforms. And definitely, it's a fascinating matter and topic to discuss. Thank you, ASIPPI and AIPPI, for inviting me to moderate this wonderful webinar. It was a pleasure, and thank you everyone for listening and joining this webinar.
Thank you so much, Jose Antonio. I will be doing the closing remarks on behalf of Diego Palacios because he's at his LLM in Franklin Pierce, so he had to go into class. So thank you all for joining us for this webinar. On behalf of ASIPI Joven, we would like to express our sincere appreciation to IPPI Young Members Committee for this valuable collaboration, as well as to our distinguished panelists for sharing their time, experience, and insights on such a timely and relevant topic. Before we close, I would like to take this opportunity to invite you to the 23rd ASIPI Congress, which will be held in Buenos Aires from November 29th to December 3rd. As part of this major event, ASIPI Joven will host a special activity on November 30th from 5:30 to 6:30 p.m., where we will continue to strengthen our community, share experiences, and create new opportunities for young members. Thank you once again for being with us today. We look forward to seeing you very soon, both in Buenos Aires and at our upcoming activities. Blanca, I'll pass on the word to you.
Thank you, Giselle, and thank you all for joining us for this insightful exchange of ideas. It has been a true pleasure to share this space with ASIPI Joven, with whom we continue to strengthen interinstitutional collaboration and create meaningful opportunities for learning and professional growth. I would also like to take this opportunity to invite you to our upcoming international gatherings, our Trilateral Young Members event, which is organized by the AIPPI Young Member Committees of France, Germany, and Italy, which will be held in Paris in November 14th in hybrid format. The AIPPI midterm meeting in Marrakesh with registrations opening on November 13th. Both will be excellent opportunities to reconnect, continue learning, and build stronger ties among young professionals from around the globe. Once again, thank you everyone who participated today, especially to our panelists and colleagues from ASIPI Joven. We look forward to seeing you at our upcoming events.